Welcome to Bond University on iTunes U.
Thanks very much, Patrick. I really appreciate that introduction. It's great to be here in this beautiful country and with this beautiful weather. Patrick, I'm going to try to go 45 minutes. But if I don't, does it count that I played the piano for a couple of minutes last night in the University Club? Because I want to get full reimbursement. So I think it's probably fair to say that most people here are not big fans of preventive detention. I'm not a particularly big fan of preventive detention either, but Patrick has reminded me that a chapter that I wrote for a book that he and Bernadette McSherry edited was reviewed by someone who called me a vociferous crusader for preventive detention. I'm not sure that's accurate, but I'm quite willing to be the designated advocate for preventive detention during this conference so that people can throw darts at somebody. You'll see from my talk, I'm not really a vociferous advocate for preventive detention, but I am willing to contemplate its existence. And what I've done in some of my writing is try to develop principles, to be more specific, 7 principles that might govern preventive detention if and when it takes place. So that's what I want to focus on today, are these 7 principles. But before I get into that, I want to talk about the jurisprudence of dangerousness, the law of preventive detention in 2 jurisdictions outside of Australia. To be specific, Europe and the United States. I think it's very useful to find out what's going on in other countries, specifically with respect to preventive detention, before we consider what might happen in Australia and what should happen in Australia. I think to summarize what I'm about to say, Europe has a fairly nuanced approach to preventive detention. The United States, not so much. Okay, that's what I'm going to say in a nutshell in terms of how these different jurisdictions handle preventive detention. So the leading case in Europe comes from the European Court of Human Rights, and it's called M versus Germany. John mentioned it last night. And I have up here on the screen the facts of M versus Germany, or rather the criminal history of M, not his real name, I think. But in any event, this is his criminal history. It's worth putting up here because I think this is representative of the kind of person that gives the legal system major headaches. Okay, a guy who continuously commits crime. He gets sentenced, released from prison, and once again commits crime within a very short period of time. And you can see from M's history, this is the kind of thing that he did repeatedly. It's also very similar to the facts of the Farden case. Farden's been mentioned a couple of times. It's also similar to the facts of Leroy Hendricks' case. I'm going to be talking about the Hendricks case in just a little while. That's a United States case that has to do with preventive detention. There are people like this who continually commit offenses. And they're the kind of people, I think, that trigger the interest in preventive detention that we see in jurisdictions around the world. We want to do something about these people beyond just sentencing them over and over again to very short terms. We want to keep them sequestered so they don't threaten the public. So, ironically, by the time M's case gets to the European Court of Human Rights, he's 51 years of age. He's probably pretty burned out at that point. He's probably not going to commit any more criminal offenses at that point. But he obviously committed quite a few criminal offenses before that point. And the key one I want to focus on is the 2 he committed at age 30. He committed attempted murder and robbery at age 30. He was convicted for those crimes in 1986. And after that conviction, he was sentenced to 5 years, roughly the 10th time he'd been put in prison for crimes he committed. Also, though, at the time of this sentence, where the court imposed a 5-year disposition, the court stated that under Section 67 of the German Code, if it turns out that at the end of that 5 years, he's likely to commit offenses, his confinement could be continued for another 10 years. And this is what I'm going to call a preventive disposition. In other words, the court was going to add 10 years for preventive reasons. This is very similar to the kind of statute involved in the Farden case, the dangerous sexual offender statute, where individuals can be preventively detained after they finish their sentence. Though in Farden it involved an indeterminate period, here under Section 67 it involved a 10-year period. Okay, so what happened next? Well, 5 years later, after his sentence ended, the court found, yes, Mr. M, you are likely to commit offenses. We're going to keep you in for another 10 years under authority of Section 67. Then what happened was very interesting as a legal matter. In 1998, the German legislature amended Section 67 to remove the 10-year limitation on the preventive disposition and make the preventive disposition indeterminate. Okay, so it changed the nature of the statute to make it much more like the statute involved in Farden. 2001, what does M argue? Well, of course, he argues, I'm no longer dangerous, plus the 10 years has expired. It's time to let me go. But because of the amendment to Section 67, the sentencing court said, no, we're not going to let you go. We are instead going to continue to confine you under the new version of Section 67. Well, M argued that that was illegitimate. It was a double punishment. That's one of the arguments made in Farden as well. Look, I've already served my sentence for that attempted murder and robbery. You can't continue to confine me on that basis. It's a violation of what we Americans would call double jeopardy, the double jeopardy prohibition. But the sentencing court said that this continued confinement beyond 10 years was proportionate both to his previous offense but also to the danger he represented in the future, proportionate to the risk that he presented. This proportionality idea is something I'm going to come back to later. So M challenged this extended disposition. In all of the German courts in which he could challenge it, all the German courts rejected his challenge, essentially saying, look, that extension beyond the 10 years is not a penalty. It's not a punishment. Okay? Andrew predicted that this issue would come up later on in the day, and sure enough, it already has. Okay? What the German appellate court said is, this is not a penalty, it's not a punishment, it's a preventive measure. And under German law, the court said, preventive measures are permissible if there's a weighty government interest justifying the preventive measure. Well, in this case, the court found a weighty government interest, that is, M's dangerousness. So M lost in the German courts. So he took his case to the European Court of Human Rights. And as many of you know, the European Court of Human Rights is sort of like a Supreme Court nowadays in Europe. What the European Court of Human Rights doesn't have to be followed by European countries, but more and more often European countries are feeling heavily influenced and in fact are following what the European Court of Human Rights says. So the impact of M could be and in fact has been fairly significant. What did the European Court of Human Rights hold in this case? It disagreed with the German courts. It said both the 10-year disposition after M's 5-year sentence plus the extension of that 10-year disposition were penalties. Why were they penalties? Why were they punishment? For some of the reasons we've heard discussed already. First of all, the disposition was severe. Once you add 10 years, once you tack on the indeterminate disposition to the 10 years, it becomes one of the more severe kinds of dispositions that can be imposed under the German criminal code. But more importantly, the European court said it found it striking, and that was the word the court used. It found it striking that M was housed, in effect, in an ordinary prison. Now, granted, it was a different wing of the prison. Much like we heard on the video presentation today, sometimes they just move somebody across the fence to another kind of building. But essentially, the European court held that M was being held in an ordinary prison. And most importantly, more important than even that fact, was the fact that M was not receiving sufficient treatment, which the court in M defined as something involving a team of multidisciplinary staff, intensive work with inmates on an individual basis, within a coherent framework for progression toward release. And the court also emphasized release has to be a realistic option. Okay, it can't just be something thrown out there in the abstract. It has to be a realistic option. And the court found that M was not receiving this treatment. Therefore, everything that happened to M after 1991 was a penalty. So then the European Court turned to Article 5, Section 1A of the European Convention on Human Rights, which states that penalties may only be imposed after a lawful conviction. Okay, penalties may only be imposed after lawful conviction. And the European Court said the 10-year preventive disposition, the one that occurred between 1991 and 2001, was a permissible penalty. It was a penalty, but it was permissible. Why? Because the sentencing court explicitly referenced the possibility that preventive detention would take place after the end of the 5-year sentence. So it's very important in the European Court that the sentencing court mentioned this preventive disposition. On the other hand, the extension beyond that 10-year period was an illegitimate penalty because the sentencing court had not made reference to it. Obviously, it could not have because Section 67 wasn't amended until after the extension in 1991. So there's a lot more to this opinion. It goes on and on and on. I think there are about 300 paragraphs, but that's about all I'm going to say in connection with it right now, except to state that even though M did clarify matters a little bit, and it did strike a blow against preventive detention, at the same time it left at least 2 questions open, which I think are very important questions. First of all, what if the government does provide the kind of individualized treatment that the European Court described? Does that convert what once was a penalty to a preventive measure? So in other words, if M did receive this individualized treatment within a coherent framework and a multidisciplinary team was involved in the treatment, would that convert the penalty in preventive measure? The European Court didn't answer that question, at least in M. The second question is, let's assume it is a penalty. Okay? Even if there's lots of treatment, let's assume it is a penalty. If the sentencing court makes it clear from the outset that this penalty might be preventive in nature, does that avoid the import of M versus Germany? So in other words, if we incorporate the preventive detention into the sentence itself, does that avoid the import of M versus Germany? And both of these questions are very important to answer. In Europe, much less in Australia and the United States, because a number of European countries have statutes very similar to Section 67. So these two questions are very important to answer. And if they're both answered in the affirmative, what it means is that a government can avoid the import of M versus Germany simply providing lots of treatment during this preventive disposition, or by making sure that the sentencing court references the preventive disposition at the front end. So what's happened in the meantime? There's actually, as I said, there's been a lot of activity in Europe. Well, the German Constitutional Court, a year after M, and inspired by M, came down with a decision saying, you know what? People like M, who are confined under Section 67, are being held in facilities that are not really distinguishable from prison. So from now on, at least until the German legislature gets its act together, we're only going to allow preventive dispositions of people who are mentally disordered, whatever that means, and extremely dangerous. So the German Constitutional Court tried to limit what goes on with post-sentence commitment in this decision. And the European Court of Human Rights itself, this Hayden decision is from the European Court of Human Rights, it suggested, it didn't hold, but it suggested in the Hayden case that post-sentence commitment can only take place in mental hospitals. So trying to move away from this prison-like setting situation that was involved in M. Now, neither of these decisions specifically answer this first question. They suggest that unless the disposition takes place in something akin to a mental hospital, post-sentence commitment is not permissible, but they don't specifically answer the question. What about the second question? Well, here we've got some decisions from the European Court of Human Rights that actually precede M versus Germany, and they suggest that the answer to this second question is affirmative. Okay, so for instance, in Vag-Drugenberg versus Belgium, the European Court of Human Rights upheld a sentence enhancement based on risk for an habitual offender. And in the Kafkiras case, the European Court of Human Rights upheld an extension of a sentence beyond the 20 years that was permitted by prison regulation, because the original sentencing court had initially imposed a life sentence on Kafkiras, suggesting that so long as the preventive disposition is part of the original sentencing order, it's going to be permissible. And remember the holding in M itself. Remember, even though M did find impermissible the extension of M's disposition beyond the 10-year period, it upheld the 10-year preventive disposition that took place after his 5-year sentence ended. Why? Because the sentencing court specifically referenced Section 67. So again, it appears that the answer to this question is yes, though it's not entirely clear, because if you read all 300 paragraphs of M, it's clear that the European Court of Human Rights is pretty hostile to the idea of preventive detention. And it may be when it comes back to the second question and explicitly addresses it, it will end up saying, you know, we even have problems with preventive detention when it's folded into a sentence. So I'm not sure that either of these questions have been answered completely. And at this point, I want to turn to U.S. law to see what it might have to say about these two questions. And the key case here is the case that John mentioned yesterday, Kansas versus Hendricks, decided back in 1997. Leroy Hendricks was an individual who committed a number of sex offenses just about when he was going to be released from prison from his last prison term. The prosecutor filed a petition under what in essence was a Dangerous Sexual Offender Act, saying that he was dangerous and that he needed to be confined beyond the term of his sentence. He in fact was committed under that statute, which is very much like Section 67 in the German Code. And he argued, just like Farden did and just like M did, that this was double punishment. But the Supreme Court of the United States said it was not. It disagreed with the holding in M. It didn't cite M. The Supreme Court of the United States never cites any foreign cases. It's just beneath them to do so. But, and of course, also, 1997 preceded 2010. But even if, that's another reason it didn't cite M. But even if M had existed, I can guarantee that it would not have been cited, at least as in any way influential in the majority opinion, or in the dissent for that matter. The court's decision was that this post-sentence disposition was not punishment, was not a penalty, and therefore double punishment was not occurring for a number of reasons, primarily because the whole issue in this preventive detention hearing was forward-looking, was an attempt to determine what kind of risk Hendricks posed. Now, it's true in the detention proceeding, information about past conduct was introduced. But the Supreme Court emphasized this past conduct was not introduced to see if Hendricks should be punished for it, but rather was merely introduced to see what kinds of crimes or antisocial activity he might engage in after the hearing. The court said this is a civil or regulatory proceeding, not a criminal proceeding. It is not interested, to use Andrew's word, in punishment or deterrence. It's interested in incapacitation and rehabilitation. Now, as Andrew pointed out, incapacitation and rehabilitation are also purposes of punishment, but the court said the primary purpose of punishment are retribution or punishment and deterrence, not incapacitation and rehabilitation. And the focus of this hearing, the court said, is only incapacitation and rehabilitation, not punishment, as evidenced by the fact that there was no requirement on the part of the government to show culpability or scienter, to use the Latin phrase. No requirement to show blameworthiness. The focus was entirely forward-looking. So the Supreme Court disagreed with what the M versus Germany court eventually held. Not a penalty. It did put a limitation on post-sentence commitment. It did say that people in Hendricks' situation had to have a mental abnormality that made them dangerous beyond their control. But the court also made very clear that this mental abnormality does not need to be akin to a psychosis. Okay, what we have traditionally considered to be the kind of serious mental illness that can lead to preventive detention. The court said all the government needs to show is some kind of significant volitional impairment. And in the later case of Kansas versus Crane, the court went on to say, we are not requiring complete lack of volitional control. We're only requiring serious difficulty controlling one's actions when we talk about dangerousness beyond control. So that was the court's holding, and it was limited in the way I just described. The lower courts have pretty much applied Hendricks in an expansive way. People have been committed under these statutes not only if they have psychosis, but also if they have a personality disorder, so long as they also can be shown to be dangerous. So Hendricks then argued, okay, maybe I'm mentally abnormal, and that makes me dangerous beyond my control. But my specific disposition is still impermissible. Why? Because I'm sitting there in a prison-like setting receiving virtually no treatment. Sound like a familiar argument? It's exactly the argument M made. It's the kind of argument Fardin made in the Fardin case. He said, it's just impermissible for you to hold me when you're not giving me treatment. The Supreme Court rejected that argument as well. Said, yes, treatment does have to be recommended, but treatment can be an ancillary purpose of the preventive detention. Incapacitation can be the dominant purpose of this kind of disposition. Treatment needs to be recommended. Maybe we need to try to treat them, but if it doesn't work, no big deal. And in fact, in Sealing versus Young, the court reiterated that idea. It did say there had to be an attempt to treat the individual, but there was nowhere near, in this case, which is a Supreme Court case, nowhere near the kind of strong language that you see in M versus Germany. Remember the language I read earlier. Nothing akin to it at all. So basically, as a result of Hendricks, it appears, in answer to that first question raised after M, that in the United States, it's permissible to hold a person after they've completed their sentence if they've got a mental abnormality that makes them dangerous beyond their control, even if that disposition is in a prison-like setting and not much in the way of treatments being provided. What about the answer to the second question left after M? That is, what about preventive detention as part of the sentence, folded into part of the sentence, as opposed to post-sentence commitment? Well, here we have case law from the United States Supreme Court going all the way back to 1937, saying a sentence may be imposed solely on the basis of risk, solely on the basis of a person's dangerousness. And if there was any doubt about that, in 1976, the court made it crystal clear that a sentence can be based solely on a finding of dangerousness when it upheld an execution based on a finding that a person was dangerous. So there's no doubt that risk can form the basis for a sentence. And in fact, the court has also suggested that indefinite sentences, that is, sentences without any maximum point to them, are also permissible. Well, given that line of decisions, defendants have tried another line of attack. They said, look, a really long sentence or an indefinite sentence without a maximum limit are a violation of the American Constitution because they violate the cruel and unusual punishment clause that we have in our 8th Amendment. That argument, too, has been rejected. In Ewing versus California, the individual was convicted of stealing a set of golf clubs. That was his crime. However, he had 3 prior felonies, all of it about the same level. I think he may have stolen golf clubs one time, tennis racket another time, that kind of thing. He was into sports. So he had 4 felonies, and under the relevant statute in California, he was given a sentence of 25 years to life. 25 years to life. And he said, wait a minute, that's cruel and unusual punishment. Totally disproportionate to what I did, which is stealing a set of golf clubs. There may be a couple other crimes in the past, but I've already done my time for those other 3 crimes, so those really shouldn't count, or shouldn't count for much. But what the Supreme Court held is that this was not cruel and unusual punishment, and I think it's worth reading what the court said, if I can find it, in this case. What the court said is nothing in the 8th Amendment, which is the amendment that has to do with cruel and unusual punishment, prohibits California from choosing to incapacitate criminals who have already been convicted of at least one serious or violent crime. Notice, you only need one serious or violent crime. You can incapacitate them based on that. Recidivism has long been recognized as a legitimate basis for increased punishment and is a serious public safety concern. So, the answer to the second question in the United States seems to be, so long as you keep preventive detention within the sentencing context, you can do anything you want. Okay? You can even execute someone. Okay, so I think a lot more thinking needs to be done about when preventive detention is permissible. We need to flesh out a lot more than even the European Court of Human Rights has done, much less than the extent to which the Supreme Court has thought about this. We need to flesh out more precisely when preventive detention is permissible, if ever. And as I said earlier, in my writing I've tried to develop principles that would govern preventive detention, and I've come up with 7 principles. It's a lucky number. So I'm hoping that they actually do provide some conceptual framework for preventive detention if and when it's going to occur. Now notice I'm not expressing an opinion about preventive detention right off the bat. I'm not saying I love preventive detention and I want it to happen as often as possible. I'm saying if it does occur, we need to think about principles that would govern how it would operate. And these are the 7 principles. I want to go over them briefly. I want to go over principles 1 through 3 and 5 through 7 pretty briefly. I'm going to spend a little bit more time on principle 4. So the first principle is the legality principle. And if you remember the question I asked Andrew and Ian this morning, it was trying to get at this issue of legality. When can we intervene in someone's life? When can we call an act criminal? When can we call an act sufficiently serious that the state can deprive the person of liberty? And this is what the legality principle is all about. What it states is that the state cannot engage in preventive detention unless the person has committed a crime or at least engaged in imminently risky conduct. Now, in the context we're talking about, sentencing and post-sentence commitment, a conviction would be required. There has to be a conviction. In fact, there always has been a conviction, right? Both in sentencing context and in post-sentence commitment, there has been a conviction. There does have to be this conviction. An arrest, mere suspicion, the presence of a risk factor is insufficient under the legality principle to trigger preventive detention. Otherwise, the government would have far too much power to incapacitate people at will, simply because I think the person's dangerous. And I think Gattaca, the movie Gattaca, and less dramatically, but nonetheless, Minority Report, those 2 movies I think illustrate what can happen if we don't have the principle of legality limiting when the government can engage in preventive detention. So that's the legality principle. I'll be glad to talk more about it later, but that's all I want to say about it for right now. Then I want to move to principles 5, 6, and 7. These are evidentiary and procedural principles that would govern the operation of preventive detention. And what principle 5 states is that the government is going to try to preventively detain someone on the basis of dangerousness, on the basis of risk. It has to use the best scientific evidence possible. And in my opinion, that means the government has to use actuarial instruments, actuarial risk assessment instruments. Now, I know for some people in the room, and maybe everyone in the room, actuarial assessment is evil incarnate. But I happen to think that it's the lesser of all the other evils. I admit that actuarial instruments and actuarial risk assessment, very flawed. But I think all other forms of risk assessment are even worse. Okay, clinical risk assessment and what behavioral scientists call structural professional judgment are insufficient for preventive detention purposes because they don't provide us with a concrete estimate of probability, the probability of risk. What you get with a clinical risk assessment is, I think he's dangerous, or he's highly likely to reoffend. What you get with structured professional judgment is, the guy fits in a high risk or medium risk or low risk category. The problem with those kinds of pronouncements is we don't know what the hell they mean. We have no idea what they mean. There is no empirical basis for those kinds of assessments. It's a seat of the pants assessment with clinical risk assessment. With structured professional judgment, it clearly is structured. And I'm not going to go into detail what that is. Many of you, I think, know what it is. If you don't, talk to me later. In any event, it is better than just seat of the pants psychiatric assessment, but it still doesn't give you a precise probability estimate. Whereas actuarial instruments, as flawed as they are, and they're no doubt flawed, if they're validated on the relevant population, give you a probability estimate. I see Ian shaking his head no, so I'll be glad to talk about that later. Now, as he said earlier, to the extent they do provide probability estimates, they may not provide particularly impressive probability estimates. That is anything over 50%. I want to address that in just a second. But they do provide concrete probability estimates, and that can provide the decision maker with information relevant to making the normative decision as to when we should be able to preventively detain. It's better information than just a statement, oh, he's likely to reoffend or he fits in a high-risk category. It's all bad. Don't get me wrong. I'm not saying we can predict well. I'm not saying risk assessment's good. I'm just saying if we're going to do it, we should require the government to use actuarial proof if it's available. Now, I also say in Principle 6, however, that the subject of the preventive detention can try to rebut the state's actuarial case with clinical risk assessment. In other words, it can use what I consider to be the less accurate kind of risk assessment in order to rebut the state's case, particularly through introduction of evidence about protective factors, that is, factors that counter risk assessment, that were not incorporated into the actuarial instrument. And I also say in Principle 7 that the subject ought to be able to force the state to periodically reprove the degree of risk that's necessary in order to preventively detain someone. And that hearing has to be one in which the subject has voice and a hearing in which we avoid executive domination of the process. I think in a lot of jurisdictions, when these preventive detention hearings take place, we're pretty much letting the executive branch dominate the decision-making process. And I think the judiciary has to be involved in this. So that's those last three principles. Then I want to talk about principles 2 and 3. These are the justificatory principles that I think need to apply. And they're really the most important principles in a sense. The risk proportionality principle is the idea that the government, before it can preventively detain someone, has to demonstrate a magnitude and probability of risk that's proportionate to the nature and duration of the detention that's contemplated. Okay, I'm going to spend more time on that in case that was a little bit too much detail all at once. But by analogy, many of you are familiar with the statement that's often made, that criminal punishment ought to be proportionate to a person's blameworthiness. Okay, that's relatively standard kind of analysis under retributive theory. What I'm suggesting here is, in preventive detention context, an analogous proportionality theory, that the state has to demonstrate a degree of risk that's roughly proportionate to what the state plans to do to the individual. Okay? So what does that mean? In the context we're talking about, where we're depriving people of liberty based on an assessment of risk, I would argue the state needs to demonstrate a very high level of risk. And not only a very high level of risk, but a high level of risk that the individual will commit a serious crime. Not go out and sniff petrol or buy drugs, the kinds of things that we alluded to this morning. But it has to be a serious risk of serious crime. Now, what's a serious risk? Well, I don't know. I think that would have to be something that legislatures and the judiciary working together would have to come up with. But I could see certainly a level somewhere around 40 to 50% before a person can be preventively detained. And that kind of percentage can only be obtained through an actuarial instrument. You're not going to be able to get that from clinical risk assessment or structured professional judgment. So some degree of risk around that area that the individual commit a serious crime in the foreseeable future or preventive detention cannot take place. Now, I know that in practice, that particular idea is going to be hard to implement. Courts are going to say, he looks dangerous to me. I'm going to put him away. That's why I insist on actuarial prediction, because actuarial prediction gives you the number. And unless you have that number, courts can fudge all sorts of things. Now, granted, the number may be flawed for all the reasons we talked about. And in fact, the defense can show that the number is flawed. But at least you have a number to work with. Okay? Otherwise, it's totally unclear when the government can prove the requisite degree of risk in order to allow preventive detention. The risk proportionality principle also requires that the longer a person is detained, the more risk you have to show. The longer a person is detained, the more risk you have to show. So if we start with a 30 to 40% showing, after we keep them a couple of years, you got to show 40 to 50%, which may be impossible, which means what? You got to let them go. You can no longer detain them. Okay? The other principle, not the other principle, principle number 3 works in tandem with the risk proportionality principle. And it's something that comes from international law as well as American constitutional law, though the Supreme Court sort of ignored it in this context. But it's a pretty well accepted idea that the government must adopt the least drastic means of dealing with the perceived danger. Okay? Which means what? What it should mean, based on the kinds of things that Andrew was talking about this morning, what it should mean is confinement as a last resort. Confinement should be the last thing we think about if our goal is to prevent violence or other kinds of harm to society. Why? Because in fact, community interventions are often much better than detention, especially in the kind of prisons that Andrew was talking about. It's much more effective at reducing crime. Just to give you one example from my work with respect to juveniles, some of you may have heard of multisystemic therapy. This is a very intense therapy that takes place in the community over a 3 to 4 month period. It involves interaction with the family of the offender, with peers of the offender, with the neighborhood and the context, the system, the multi-systems in which the offender operates. It's found to be extremely effective at reducing violent crime by juveniles, much better than prison, which tends to exacerbate or enhance recidivism on the part of juveniles. So I think if you take this particular principle seriously, confinement would not occur anywhere near as often, at least in the preventive detention context. Okay? At least in the preventive detention context, it would be something to be relatively rare. The other import of the least drastic means principle is that if there's treatment out there that can reduce the length of confinement or the length of the intervention, it has to be provided by the government. Why? Because that's the least drastic way of preventing the perceived danger. If there's treatment out there that can reduce the danger and thus reduce the duration of the confinement or the intervention, it has to be provided. And I particularly like that argument because it provides you with the principled argument for a right to treatment. Okay? Under this principle, there's a right to treatment, not just what the Supreme Court says, well, you need to recommend treatment, but who cares whether it happens or not. There is a right to treatment under the least drastic means principle because only by providing treatment that will reduce dangerousness do you in fact achieve the least drastic way of handling that danger. So I've talked about these 6 principles very quickly. Be glad to talk about them more during discussion if you want. Suffice to say that I think if these 6 principles are adhered to, that indeterminate sentencing is permissible. In other words, that second question that was left after M, whether preventive detention in the context of sentencing is permissible, I think the answer to that question is yes, if these 6 principles are adhered to. Okay? Big if. I think Heather's going to point out it's a huge if. It's hard to follow these principles. But nonetheless, if they are followed, I think indeterminate sentencing is permissible. What I want to focus on for the remainder of discussion, and I think I'm going to do 45 minutes, Patrick. I'm really excited. Full reimbursement. Hot dog. Okay. This 4th principle is the principle that governs when preventive detention is permissible outside the criminal process. Okay? Outside the criminal process. So when does that occur? When does preventive detention occur outside the criminal process? That is not in connection with indeterminate sentencing, but in other contexts. Well, we've talked about one a lot already, post-sentence confinement. Right? That's outside the criminal process. The person served his or her criminal sentence. Now we're going to confine them further. That is detention outside the preventive detention outside the criminal process. It's the kind of issue that was involved in M, the kind of issue that was involved in Hendricks and in Forden. But there are a lot of other types of preventive detention that occur outside the criminal process that have been well accepted for centuries. One is civil commitment of people with mental illness. Okay? That's a form of preventive detention. It does not occur in connection with the criminal process. It's a civil process. Another example, quarantine. When we quarantine people with infectious diseases. That's not criminal punishment. It has nothing to do with the criminal system. But it is a form of preventive detention. We're making that person stay at home or in some kind of sanatorium. Same thing with prisoner of war camps. That is preventive detention outside of the criminal process. Okay? We're detaining these people because of the danger they pose to us, our society, and that is another kind of preventive detention that takes place outside of the criminal justice system. What the criminal justice primacy principle is meant to address is when this kind of stuff is allowed. When is preventive detention allowed outside the criminal justice system? And my answer to that, and actually I've written a whole lot on this, and I'm not going to be able to come anywhere near explaining it all because you only gave me 45 minutes, Patrick, which is really cool. But this is the criminal justice primacy principle in a nutshell, that dangerous people have to be handled through the criminal justice system when at all possible. When is it not possible? Only when the criminal justice system cannot prevent the individual's antisocial behavior because the individual is undeterrable by the criminal law. Now, what do I mean by that? That's a very amorphous phrase, right? I don't mean undeterrable in the sense that we talked about this morning. I think it was Andrew who talked about, but if you're arrested, you have a 1 in 100 chance of being convicted or something like that. I'm not talking about the kind of person who says, ooh, I can do this and get away with it. Or I can do with this and my lawyer will be able to make some kind of fancy argument and I'll be able to avoid criminal punishment. That's not what I mean by undeterrable. In fact, that person is deterrable in the sense they're worried about the criminal law. They're thinking about it. Now, they may be doing the calculation and saying, I can probably get away with it, but they're at least thinking about the criminal law. What I mean by undeterrable is a person who's impervious to the criminal law, oblivious to the criminal law, doesn't care about it, or the criminal law has no effect on the person's harm or the person's risk. So let's apply that idea, the undeterrability idea, to the last three forms of preventive detention. They are civil commitment, quarantine, and enemy combatants. Are they undeterrable? Is it permissible to preventively detain people with serious mental illness, people who are contagious, and enemy combatants? Well, I think you can make the argument they are undeterrable. Let me illustrate how, and then you can disagree with me. Many people have before. People with serious mental illness could be said to be undeterrable. Why? Because when they have psychosis, when they're thinking about committing a harm, or in fact they do commit a harm, they often don't realize they're committing a crime. For instance, a person with delusions who kills someone may not realize they're killing a human being, may think they're shooting a tree or some other inanimate object. Or more realistically, a person with paranoid delusions may believe the person they're killing or hurting is trying to hurt them. Now, they're totally wrong about that. Objectively speaking, there's no harm to them, but their delusions make them think that the space alien or whatever it is that's confronting them is in fact about to hurt them. They think they're acting in self-defense. In that situation, they're not deterrable. They don't think they're committing a crime. That basically defines what the insanity defense covers. Okay? So I would argue they're undeterrable. What about people with infectious diseases? How does the undeterrability idea work there? Totally differently, but when a person who's contagious is out in public, it's inevitable their germs are going to infect the public, the rest of the public, no matter what the criminal law says. The criminal law has absolutely no power to address the risk posed by an infected person, a contagious person. The germs are going to be airborne regardless of what the criminal law says. It just cannot deal with the situation. So I think that's a form of undeterrability as well. What about enemy combatants? These are people who are under orders to kill or be killed. Okay? I think you can make an argument they're also undeterrable as well, at least by the criminal justice system. They don't really care about the criminal justice system. They're at war. They're under orders to kill people. And if that doesn't convince you, you may know that the laws of war say that enemy soldiers are justified in killing. Okay? If it's a war, if it's a legitimate war at least, they're justified in killing. So again, they're not in any way affected by the prospect of criminal punishment because they're in fact justified or authorized to engage in killing, if it's a legitimate war. So I would argue that, and again, I'm not stating definitively that preventive detention in those last three situations is permissible, but under undeterrability rationale, they could be permissible in the ways that I've talked about. But what about post-sentence confinement? That's what we're really talking about here. I think that's what we want to focus on. How does the undeterrability rationale apply in the context of cases like M and Farden and Hendricks and so on? Well, as I said before, most people subjected to post-sentence confinement are not psychotic. Now, if they are, they might be eligible for preventive detention for the reasons I stated earlier. They literally are not deterrable because of the delusions. But most people who are confined after sentence are not suffering from psychosis. They have some kind of personality disorder. So they don't have delusions. Would those people ever be eligible for post-sentence confinement? I think most of the time not. Okay? Because I think most of those people are deterrable in the sense that I'm defining deterrable. But I could see some people with severe impulse disorders might come under the rubric of undeterrability. But it would have to be very serious, impulsive problem. For instance, to use the nomenclature the common law uses, the kind of person who would commit a crime even if a police officer was standing at his or her elbow. Or to use language that the Minnesota Supreme Court used, the person has to be utterly incapable of controlling their behavior. Or to use the language that the Hendricks court used, dangerous beyond their control. But I think you have to take that language seriously, as opposed to what's happening in the United States. It has to be taken seriously, or it wouldn't meet the definition of undeterrability. So, what about specific cases? Were any of these people undeterrable? Well, I don't know enough about M, and I don't know enough about Farden to know whether they are undeterrable. But I would suggest that Leroy Hendricks, the person who was involved in the Hendricks case, was undeterrable under the definition that I'm giving. Why? Because just as he was about to be released from his 9th conviction for child molestation, 9th conviction for child molestation within a 22-year period, he stated, the only way I'm going to stop molesting kids is if you kill me. That was his own statement. I would suggest that kind of person might be undeterrable. If there anyone is, that person's undeterrable. And then I threw in Gary David. Many of you may know about the Gary David case because he comes from right here in Australia. 2 decades ago, he was convicted for shooting a woman and 2 police officers and given a 14-year sentence. He committed that criminal act right after he'd been released for a previous offense. So he's one of these people that gets sentenced, gets released, commits another crime almost immediately. He was given 14 years. While he was in prison for those 14 years, he assaulted 15 guards and inmates. Okay? And just before he was going to be released, the relevant court stated, and again I want to read this to you, if I can find it. Oh, I can't find it. Too bad. But in any event, what this court held or stated was that Gary David, here we go, his underlying anger and resentment would be almost certain to rise to an explosive level as soon as he felt thwarted or subjected to stress. I would suggest that maybe Gary David also was undeterrable in the sense I'm talking about. So I could see a very limited category of people being eligible for post-sentence confinement on the grounds that they're undeterrable in the sense that I've described. But remember, even if they're undeterrable, that only takes care of principle number 4. Still have to meet all the other principles that I've talked about in order to allow post-sentence confinement. So at least in theory, I think there are a whole lot of limitations on preventive detention. I think it's unfair to say I'm a vociferous crusader for preventive detention. I might be a vociferous inquisitor of preventive detention, but I don't think I'm a crusader for it. However, I would allow it, at least in theory, under these conditions. So I think I'll stop there.
For more information, visit bond.edu.au/iTunesU.